So are there laws in the state of Georgia that address drivers who have a BAC below point oh 0.08?
Well, there's essentially two ways you can be charged with DUI alcohol. One is DUI per se, where you have over a point oh 0.08 blood alcohol content, and then the other way is DUI less safe, and that one doesn't require any evidence of what your blood alcohol content is, but it requires that the state prove that you were in control of a motor vehicle and that you were under the influence of alcohol to the extent you were less safe to drive. So if you do a breath test and you blow under a point oh 0.08, the state is forced to try and prove the case as a less safe to drive case. Similar to if you refuse the test, that's the statute that they're trying to prosecute you under.
Okay.
Now, I think the state has a lot of trouble proving cases where the person's blood alcohol content is under point oh 0.08. I think a lot of people, if you go ask a random person on the street, they would think that if they took the breath test and blew under a point oh 0.08, then they're not going to be arrested for DUI.
Right.
I have that question come up all the time, and that's pretty much a consensus of what people in society think. In fact, you don't actually take the breath test until after you're in handcuffs and under arrest, and a lot of prosecutors will prosecute those cases, and a lot of times you get them reduced to reckless driving or reduced to something else, but prosecutors still tend to prosecute those cases. But if you do fight those cases out, take them to a jury, a lot of juries are not going to convict when they hear that the person took the breath test as requested and their blood alcohol content was under the point oh 0.08 quote-unquote legal limit.
Okay, that's probably because of that perception, like you just said, that people think that the law has determined point oh 0.08 over means you're intoxicated and under means you're not. I guess that's what you're saying is people's feelings, so that's why they'd be prone to not convict someone who blew like a point oh 0.05.
I think so. I mean, I think it's a bit of a fairness argument. You do everything the officer asks you to do. You agree to take the breath test that the officer asks you to do, and in fact, your blood alcohol content is lower than what the state has determined is the legal limit. And yeah, I just think most people feel like you should be not guilty at that point.
Okay.
But of course, that being said, anytime you take that case to trial, you're still at risk because legally speaking, if the officer is going to say that you smelled like alcohol and your eyes were bloodshot, and if you did the field sobriety test, they're going to say you failed all the field sobriety tests or showed sufficient clues that show you're under the influence of alcohol. And if there's no video, they're probably going to say that you had balance problems. And of course, they may say that if there is a video too, but the jury or the judge who's trying the case get to see the video and see for themselves. But
Gotcha. Do you see cases where people have been sleeping it off in a car and they're still determined to be in control of a vehicle, or are there scenarios like that?
you actually get a lot of those cases. A lot of people start driving and then realize that it's not a good thing for them to be driving, and a lot of them will go and park their vehicles. Legally speaking, in Georgia, if the key's in the ignition and the car is on, then you're in control of a motor vehicle, even if it's not being driven actively at the time. So a lot of people, especially in the summer and the winter when it's either hot or cold, they've got the car running, and a lot of them will, end up having a tough case to fight. You get a lot of people too that have their car off and they get approached by law enforcement and they get arrested. The state, if you don't admit that you drove after having consumed alcohol, in those cases, the state has a hole in their case, and that they can't prove that you actually drove the vehicle after consuming alcohol, because you could have been dropped off at your car by a friend and never actually driven it while under the influence. And so that's a hole in their case.
You mentioned earlier about immigration and DUI. So my question is, if you're convicted of a DUI and you're a resident alien or you're in some stage of immigration, can that make you get deported, or can that hurt your application for citizenship?
Well, I want to preface this by saying that I'm not an immigration lawyer.
Okay.
Any client that I have that is a non-citizen, I do advise them to go seek the advice of an immigration lawyer before entering any type of plea, or before even taking it to trial if there is a plea offer for some type of reduced charge, just so they know exactly what's going to happen. But I do think that a DUI conviction definitely can have great effects on people's immigration status, and particularly in Georgia, a lot of the jurisdictions, they use standard sentencing sheets, in which if you're convicted and given a 12-month sentence, the sentence says you're sentenced to 12 months confinement that may be served on probation. And even though that may be a completely probation sentence, or 24 hours in jail followed by 11 months and 29 days on probation, because of the way it's worded, the immigration board, and the ICE, they consider that a jail time sentence. And because of the length of it being 12 months, which is the mandatory minimum on a DUI conviction, it ends up being considered an aggravated felony. So,
Wow.
I mean, that a DUI conviction has the possibility of having a really great effect on immigration. Now, some judges will work with you on that and change the form to make sure it actually reflects what they're ordering, which is probation.
Right.
That can help the clients out a lot when the judge is willing to do that.
Yeah, I had never thought about that until you mentioned it, so that's why I asked. So thank you.
You're welcome.
So back to more normal stuff. What's your best tip when someone's had one or more drinks and they're in the process of being pulled over? What should they do, and what shouldn't they do?
Well, first of all, anytime anyone asks me this question, I strongly caution them that they should not have anything to drink, or not drink to the extent that they're going to be less safe to drive and then get behind a motor vehicle. One, it's a huge risk to society, and two, the consequences, even for a first DUI, are relatively harsh and very expensive and very time consuming and stressful. With that being said, if you do any field sobriety tests for the police officer, or the law enforcement agent that is investigating you, you're just providing them with evidence. If you give them any type of statement indicating you've consumed alcohol, or you've come from an establishment where they served alcohol, or you're coming from a party, any statements like that, they can be used as evidence against you. I generally advise people that they should tell the officer that they have somewhere they need to be, and they should, ask if they're free to leave, and they shouldn't do any field sobriety test. The only field sobriety test that I would recommend is the portable breath test, and I would only recommend that in the instance where the person feels like they're going to actually have a blood alcohol content under the legal limit.
Okay.
The portable breath test is only going to be admissible in court as to whether it's positive or negative for alcohol. So, if you've had any amount of alcohol, it's going to be positive, and you taking that test isn't going to change anything with your case. Now, after they arrest you, they're going to read to you from an implied consent card and then ask you for either a breath test or blood test or urine test. And that test, if you take that test, it will be admissible. The actual number will be. And of course, if you blow over the legal limit, or if you have a blood alcohol content over the legal limit, it can be tough to defend your case. So, generally, the case is going to get worse from you taking that test. But on the flip side, if you refuse to take that test, you may be facing a 1-year license suspension with absolutely no work permit. So, there's no right reason, and no right answer as to what to do.